You can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it. So,
Yeah, sure.
okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here is. You know that wrongfully.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry.
Um,
I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to do
kind of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
Yes.
this?
Yes, Your Honor.
You don't want help?
No.
Okay. So I'm going to do this. I'm going to apprise you if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can
If you request an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until
suppression of what evidence?
Of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained, and because of that, any violations that I could have possibly said that could impede the faith of my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
I don't know what. Okay. You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Okay. maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
Have you asked them, how do I get discovery?
No, I will be doing that.
Did you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best.
Then
you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir? Your Honor.
All right.
What do I want to do?
Here's what I'm going to do. I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could much go south for you.
Yeah, I understand.
Not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess. Court recalls case People versus Daniel McGroan.
Pass along to the people.
In Your Honor.
State your name.
Daniel Magoo.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand delivered it to the defendant as well as handing a copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No, motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also, when he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within. I really would be objecting
to the defendant showing anything to the court that he has not disclosed to the people.
So given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is, I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to, first of all, subpoena him to get his witness, statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I mean, I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures, I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this is criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay.
So that 3 is denied.
Huh?
3 is denied, Your Honor.
The whole motion's denied. Yes.
Thank you.
All 3 parts.
Number 4 was to subpoena a witness. I just responded that the defendant should follow the subpoena process that's available to him.
Understood.
Okay. Number 5 was that the defendant is requesting the court produce all audio or video recordings. I said he should go through the discovery process. That's that motion at this point. Like,
it's denied.
Thank you. Number 6, the people, I'm not exactly sure. There's a motion to seal statements.
I don't know what that meant.
I don't either.
What does that mean?
It means any statements that I made under stress to either the police officers when they were questioning me or before, after.
What do you want to do with them?
I would like to suppress them so that they don't hinder my trial experience, as I was not.
What does that mean?
Well, I was not given proper notice of my rights when I was detained, and I was questioned thoroughly afterwards.
You have to file a motion. You'd have to lay out specifics as to how and or another any statement that you made, which it doesn't sound to me like was the subject matter of necessarily an custodial interrogation, but it doesn't really matter. You're going to need to lay out all the elements of that before I would rule on that. But in its form, as it sits right now, that motion's denied without prejudice.
Thank you. My response to number 7, which is the defendant is notifying the court of exculpatory video evidence. Okay. I don't have any response to that, really, beyond the fact that it seems that these are videos the defendant has, and that he hasn't received any videos from my office yet. So I don't see how
I have video.
any piece of this.
I have videos, both FOIA requested from the Ypsilanti County Police Department and my own. I was formalizing the process for the prosecutor to build her prosecution.
To do what?
When I requested discovery items that I'm going to do following the rules of civil procedure. That's what I was, yeah.
So this last one, what are you going to do with that? What do you want the court to do?
I want the court to find on what grounds throughout the discovery process that I'm guilty of these crimes.
Okay, sir, it doesn't, you seem to want this process to work away. It doesn't.
Maybe that's the disadvantage of being pro se, Your Honor.
Yes, there are huge disadvantages because I think you know what you're doing, but you don't. It's become readily clear to me. You have no idea what you're doing.
Right.
And so I'm going to ask you, and it's going to cause some difficulty for you. So I'm going to ask you again, do you wish to be represented by an attorney?
I do not.
Okay. Motion denied.
Number 8, defendant requests the court cancel all current bond conditions pending the.
Motion denied.
Thank you. Motion to continue proceedings. People weren't opposed to adjournments, but this is actually kind of includes several things. The request is to continue all scheduled hearings until requested testimony, evidence, and hospital records are provided. So I don't have an issue if the defendant needs more time to be prepared to have a hearing, but I do have an issue if he's trying to say that he can't do anything until we subpoena somebody's medical records. So I'm going to get a search warrant for somebody's medical records and depose officers in a criminal case.
Which both of those have been denied. So by default, that would have to be denied if that's what he's asking.
I've made a note of the new address mentioned in section 10, and then there's number 11 is to seal all indictments. I don't know what this means.
I don't know.
All incident related documents and evidence. I don't know what that means.
What does that mean?
It's reiterating the sealing. Anything that I said is really all.
I don't know how that sealing would take place.
Okay.
I think you really need to think about getting an attorney. That part of the motion is also denied.
That's all. Thank you, Aaron.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No, you can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for adjournment in order to review the discovery materials I produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor. I mean,
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you.
And Your Honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about his case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case, but I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right. Probable cause conference. Me. Yeah, let me at least have some turkey before I have to deal with this again. December 5th, 2024, 9 a.m.
Yeah.
Bond will continue. Which clock is this? Is this my 2 o'clock? It is?
Yes.
Okay. So folks, if you haven't figured out why, I'm going to take a brief break. Then I will come back and start the 2 o'clock block and we'll roll through it, but I'm not going to go from that to that. Court stands in recess.
All right.
What?
And Assistant Public Defender Chinazi Carey Kimberly on behalf of Mr. Patrick Blake.
And Patrick Hansley.
Your Honor, we are asking for an adjournment. We are in negotiations with the people and yet to reach a resolution.
Pardon?
We are asking for an adjournment, Your Honor, for purposes of further negotiation.
Oh. So what do I do about his violation?
Oh. I apologize, Your Honor. I did not.
There's emotion tracking. It was great.
Okay, hold on.
What city are you living in?
Ypsilanti.
Yesterday?
Yeah, did you go yesterday, right?
Yes, I did.
He
I'm
said
sorry.
he
This
did.
is-
Did you text?
I did. They were positive. Ketamine.
For what?
Amphetamine, Your Honor, he says. The court mind passing this, I did not
Mhm.
know
I
about.
do.
Yeah, let me, with,
I do mind passing it.
No, she
Did
did.
you test? Hold it. No, I'm not passing it.
okay.
Did you go over and test?
Yes, I did. And she stated that she made a motion to the courts of retracting her violation because that she made the motion towards not retracting, but like recalling the violation request, and they granted her it, she said. Ms. Dozier,
They did what?
they granted she requested for okay.
So, Your Honor, it looks like Ms. Dozier sent an email.
Okay.
Indicating that there was a violation for his failure to contact community corrections. And then she sent another email on Wednesday indicating, good morning, I sent a violation report for Patrick Lay closing supervision interest due to failure to report to community corrections. He did make contact this morning after his mom made him aware that I called. He scheduled an intake at 1:30. So this is where he now states that he did go and test at the 1:30 time, or he went to do his intake at 1:30. You said.
And he tested.
Yeah,
yeah.
she did.
And that's what I want to get to. He
Yeah.
tested. And
According to
was
his
positive.
statements today, Your Honor, it indicates that he was positive for amphetamines.
And do you have medication that you take?
I do not, Your Honor.
Okay, that's going to be a problem.
I'm just messaging with
And I
Ms.
have to
Dozier,
disclose that
she
here.
confirmed that his test indicated that he's positive for amphetamine, so now I asked that same follow-up question is explanation for that, and I got the little levels that she's typing.
And I was this I was allowed to
This makes me jumpy.
Like, bring me to, yeah, let's say yes, so for solutions.
So, Your Honor, Mr. Lay indicates that he did have a conversation with Ms. Dozier after the positive test. Ms. Dozier is hopefully going to be able to refer him to CCOP, is what he's saying. He says that they discussed treatment options or things that would kind of help him, I think, based on the underlying offense. The 1298 is a possession charge. I think that we should absolutely focus or try and see how we can get Mr. Lay connected with substance abuse services.
When's the last time you used?
The day of my arrest, of October 30th, 10/29, sorry, 10/29/24.
On the 24th?
No, on the,
10/29/24, Your Honor, which is the date of his.
So,
arrest for the-
and then you were told on the 30th, you're saying you used before then,
yeah, I used that day.
the 29th?
Yeah.
And not, okay, young man,
What?
and not since then?
No, I have not since then. I mean, that's, okay, I took it.
Yeah, okay, so hold on. Before
In the next case, Mr. Patrick Lay is facing a bond violation for testing positive for amphetamines. He's also accused of failing to report to community corrections. The judge asks him, "When's the last time you used?" He says the day of his arrest, October 29th. Then he changes his story. About 3 days ago. The judge calls him out. "Why were you going to lie to me that it was the day of your arrest? You were scared. But why were you going to try to give me the day of your arrest?" The defendant admits, "Because that would have been before you were told by the court not to use." The judge says, "The one thing about me is I hate when people lie to me. I really do." He revokes the defendant's bond and remands him. The defense attorney asks for treatment instead of jail. But the judge is unmoved. "You haven't done anything. You continued using. That's where you are. Until such time as you decide to be honest about it, nothing's going to work anyway."
you start, hold on.
Sir.
Hold on.
Okay,
The one thing about me is I hate when people lie to me.
okay,
I really do.
okay. All right.
So, okay, so hold on. So make sure what you're gonna tell me is the truth, Mr. Allen.
So the last time I used Adderall was about 3 days ago.
Yeah.
That's the truth, Your Honor.
So why were you going to lie to me that it was the day of your arrest?
That was,
Why were you going
guess-
to lie to
I
me
guess-
that it was the day of your arrest? I can exactly tell you why you
I'm
didn't
scared.
tell me that.
Your Honor.
Yeah, you were scared, but why were you gonna try to give me the day of your arrest?
I guess.
Because that would have been before you were told by the court not to use.
Okay, well, yes, Your Honor. Your Honor, yep. And yes, also, when I did get out of bail, or holding, I guess I didn't get sent home with the paperwork saying that I had a test 24 hours after my thing, after I got released, which I didn't have with all my paperwork.
You realize we're past that now.
Okay, okay.
I understand maybe why you didn't show up. What I don't understand is why you were using. And then I don't even further understand after using, getting and testing then positive. And then when I asked you a question regarding it, you lied to me.
Okay, I guess I was scared, Your Honor, for the sake of, well, one, I had to show up because it was better to show up and I guess maybe fail and just still be here. Because I know a no-show is also testing positive as well, the same thing. But I wanted to insert myself and like I want to make myself better. And I want help because I need help, Your Honor. The lying part I'm shameful for. I'm just, like I said, I'm scared. So I do want help. why I went to Friendly Corrections, when I was told I'm into
Are
zero.
you sure it was 3 days ago? Because as I'm listening to you, I think you took it well after that 3 days.
No, sir, I'm just scared. I really am. I'm honest, sir. Like for 3 days, that's when I last took Peril. I mean, okay, well, I didn't take it. I haven't taken any today. I mean, like 2 or 3 days ago would be like the minimum.
So it was 2 or 3 days.
I mean, I haven't. Okay, so what did?
You want to know why?
I'm sorry, it wouldn't be any less than 2 days ago.
Today is the 7th.
Okay, so Tuesday. I guess it would have been Tuesday. It would have been Tuesday. I didn't look at the dates.
So that's 2 days ago, not 3.
I'm sorry, I didn't really look at the dates. I'm sorry.
Pardon?
I didn't look at the dates and I didn't know like exactly how to reference. I'm sorry. That is the truthful honor or answer, Your Honor. I'm just nervous.
So that's the truth now,
It is the truth.
after 2
Also-
attempts.
No, the second time was not like meant to be a lie. It's just I didn't really calculate the day exactly.
You're,
I'm sorry, sir. That is the
okay.
truth. That is the
okay.
truth.
it's okay.
There's no other like answer that I can give you. That's. I'm sorry. I'm just very nervous.
Me too.
Your Honor, if I may.
Please.
Yes. Your Honor, I obviously I understand exactly how, what position the court is in right now.
Me?
Mr. No, well, as
I'm in the
your
same
options.
position as when I walked
available.
out.
This
He's
is
in a worse one.
This is
But
absolutely.
go ahead, I'm listening.
Your Honor, Mr. Lay is here today. When he was told to come to community corrections, he came, knowing that it was very likely that he would test positive, but was willing to deal with the outcomes because he understands that it's important that he appears to court and he makes sure that he abides by the requirement to come to court. He has an addiction based on our underlying crime and these new bond violations. I'm asking the court to consider at least getting him into the CCOP program as soon as possible. Any other outpatient treatment program available to him. He's not a flight risk. He's here. He's here. He came to community corrections. He's come to court. I know that the people will say that one of his charges are an R&O, which is problematic in and of itself. However,
The other one's in the possession of the drugs
and then the other, that's
that he
correct.
was using after being told not to. Go ahead, I didn't mean to interrupt. I was
That's
just
okay,
trying to
Your Honor.
make it straight.
We're just asking for the court's consideration. I know traditionally in this type of situation, the court would consider a remand. We're asking that the court reconsider that and at least allow or order my client to get into some type of treatment immediately.
Well, while you can sit up there and arrange that, that's fine. But I'm not gonna have somebody not only use after being told not to, then lie to me about you.
I didn't mean to like. Okay, I'm sorry, sir. I do need help with it. I'm genuinely seeking it. That's why I came to community corrections, regardless of my fear or not.
So where are you seeking help?
I'm seeking help for resources of like people that like, I guess you can't really change. You can't change yourself until you change like how you go about like being happy. So I'm just seeking new opportunities, whether it be via work or new outlets like people that are positive in my life, that are stronger based on their efforts they made to become sober and become happy in life again, fulfilled. So I'm just seeking help as far as just being around people that can guide me and support me through becoming sober.
So have you found any?
What? I've not like genuinely, no. I'm not saying I don't really have a lot of friends anymore or support. My family is a good support. I'm really close to my family still. I'm in good terms with them.
Have you asked them to find you help?
I've asked them about moving back in with them. They live in West Spring.
Have you asked about finding help?
They said they would be 100% supportive of helping.
Pardon?
Yes, I've talked to them recently about that within the last like 2 weeks. And they said they would be supportive of finding.
Have you called any place to try to get into any treatment, young man?
I just got like links and numbers from Ms. Dozier yesterday.
So prior to you going to community corrections, you hadn't done anything?
I guess not, Your Honor.
Yeah.
but going to community corrections was my first step into like realizing that like stuff needs to change in my life. And it really does.
You know what?
Does need.
You know what? You need to stop
I know.
because you haven't done anything.
I know.
And that would have been the answer to my question. I don't know why you're trying to make everything when I ask you a question something more than what it is.
I'm sorry.
You haven't done anything. You continued using. That's where you are. So until such time as you decide to be honest about it, nothing's going to work anyway.
I think it might. I know it will. I know it will because I can't risk myself not benefit, like myself growing. Like I'm not gonna risk that. Like I would not like to risk that. I think I'm stronger than I am. Truly, sir. I know I am.
I'll adjourn probable cause to next week, November 14th, 2024 at 9 a.m. At this time, defendant's bond is revoked. You're remanded.
Thank you, Your Honor.
Yes.
So am I going to jail for a week?
Yeah.
And there you have it. The judge denied nearly all of pro SE defendant Daniel McGroan's motions, calling them frivolous and warning him that his filings made no legal sense. He adjourned the case to December 5th, giving the defendant time to review discovery, but not before telling him, "I think you know what you're doing, but you don't." In the second case, Mr. Patrick Lay had his bond revoked after testing positive for amphetamines and lying to the judge about when he last used. He admitted he used after being ordered not to, and the judge remanded him. The broader implication here is crucial. Representing yourself in a criminal case is almost always a mistake. Procedural rules are complex. Legal arguments require precision, and judges have limited patience for motions that don't make sense. If you're facing criminal charges, get a lawyer. Public defenders are available for those who can't afford one. And if you're on bond, don't use drugs and definitely don't lie to the judge about it. The truth will come out, and the consequences can be severe. If you found this case breakdown as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next session.